Hello landlords, it's Ernie and I'm back, and today we're talking all about the Texas Apartment Association lease. What's in it? What do you need to know about it? If you're using it, let's get started. My goal with this channel is very simple. It's the same goal I have in my law practice. I am set to protect my clients' most valuable assets. You'll see videos every week on this channel with that goal in mind. If you enjoy the content, please give us a like. If you haven't subscribed yet, consider subscribing. This week we're talking all about the Texas Apartment Association lease. It's that long form lease that most apartment complexes in the state of Texas use. In the comments below, let me know what you think. Do you have questions about a particular section that we are covering this week or that we've covered in some other video? Let me know, ask me your questions. I do my best to personally answer every single one of them. And if turns out enough people ask, I may make a separate video specifically on that one topic or any of the given topics that I'm given. But comment below and I'll get to you. So we will go section by section through the TAA lease so that you understand everything that's going on in it, how to use the lease to your best ability, whether you are an apartment manager, whether you are the owner of a 100-unit apartment complex, or possibly the owner of a 6-unit complex. If you're using this lease but don't know what's in it, or don't exactly understand each of the sections and how to use them, then you're not getting the full benefit out of your lease. And I'm here to set you up on a path to extracting the most benefit from your TAA lease. So we're going to start with the first section, and this may seem remedial to you, and you're thinking, wow, there's nothing I can learn from this video. I would urge you to watch through the end and see if there isn't something that maybe you've missed, something that seems as basic as section 1, which has to do with the parties involved. So here is the first section of the lease, and you would think, well, there's nothing too complicated about identifying the parties, but this is something that landlords get wrong all the time. So the first section starts out by describing who is involved. So one of the first things that landlords do incorrectly here is they do not identify all of the adults who will be living on the premises. These are the names that we want featured in this section. These are the people who should sign the lease and should be featured as tenants in section 1 of your TAA lease. Additionally, the owner should be identified. And if you're unsure whether you are, 123 Holdings Company or 2816 Elm Street LLC, you really need to get that straight. Who is the owner of the property and who is the property manager? Essentially, who you are identifying in this section is the person who is entitled to enforcement of the lease. Who receives the rent? Not who manages it, who handles it, who will ultimately receive the rent, who owns the property. If you own property in your own name and you would prefer that this section of the lease reflect your holding company, make sure you're set up in a way where this makes sense for you. Now, of course, it's also important to properly identify the unit that is being rented. I don't know how many times these kinds of errors get landlords into trouble when they're seeking to evict someone and they have perhaps changed them to some other unit. Well, they used to be at the unit that's featured in this lease, but now we're evicting them from this actual unit where they are currently staying. If your lease doesn't reflect where your tenant actually resides, you've modified your lease without modifying your lease. And so you need to make sure that your written lease is modified in writing whenever there's a change. But from the get-go, make sure that these small details are attended to and properly listed in your lease. Now, one thing that's featured at the end of section 1 is the statement, and I quote, "Neither we nor any of our representatives have made any oral promises, representations, or agreements. This lease is the entire agreement between you and us." The reason this is important is because, let's face it, we talk about things all the time and we'll make certain statements and sometimes things we say are interpreted as promises or agreements that we make in purely an oral fashion. But this particular statement protects the parties and says, look, everything that we've decided has been reduced to this written statement, and only these statements comprise what we are calling the lease. It's important that you recognize that as a landlord and don't try to make some statements outside of the lease, which clearly are not featured in the black and white, and hope to find any of that enforceable at some later date. Section 2 has to do with occupants. This is also an important section where everyone who will occupy the lease, who is not otherwise identified as a tenant, is named in this section. Is that grandma? Is this the kids? You want to make sure that you're fully aware of whoever is going to be residing on the premises and not be surprised later. If, for example, someone fails to identify someone properly, you may have cause to evict them, and this section becomes important when you confront a tenant who has unauthorized occupants on the premises. As a landlord, you can decide how many consecutive days you can have a guest. Generally speaking, 7, 14, 21 days. These are amounts that are used, whatever makes sense for you. What's important is what is reasonable. You can't put 2 days here and expect all of your tenants to simply comply with that, nor for a court to simply agree that that is an acceptable limitation on the use where guests are concerned. There's also a severability clause, and we're going to talk about the severability clause over and over and over again, because that clause comes into effect whenever you have something that's unenforceable. Just because it's in writing and both of you signed, it doesn't mean that the court is going to allow you to enforce that provision. So make sure when you're setting a limit on the number of consecutive days that a guest can reside with the occupant, that it makes sense, that it's reasonable. Section 3 is the all-important lease term. Most of us get this right. We decide when the lease begins and when the lease ends. But the key factor in this particular section is the number of days it's required for termination. And so if you put 90 days required for termination, that might end up locking your prospective tenant into a month-to-month. However, once you lapsed into a month-to-month, you might also lock yourself in with somebody that you really wish to terminate. So I generally don't recommend more than 30 days in this section. You may have a preference and you may have found it convenient to make the notice provision longer than 30 days. But generally speaking, 30 days is a good round number. It's the minimum number of days that the state will require for notice of termination. And it ends up working out pretty well. A single month should be sufficient time to make preparations. But again, you have the right to make it longer if you so wish. You generally don't have the right to make it shorter than 30 days. Next is a security deposit. Now this section has a couple of designations in it, one of which states whether or not this includes an animal deposit. A pet deposit is handled a little bit differently, and so you can designate whether any of your security deposit is intermingled with your pet deposit. Additionally, you can decide whether, upon refund of the security deposit after termination of the lease, whether a certain single person will receive that refund or whether or not it'll be jointly sent to multiple tenants in accordance with the lease. Section 5 has to do with keys and other items that you're going to get and will have to return at the time of move out. This particular section also deals with the possibility that one of the spouses or one of the occupants of the lease has been judicially removed. And if that has happened, then that judicial order essentially allows the landlord to exclude that party from the lease and no longer entitle them to keys or other access devices. Additionally, this would be the place where you would indicate whether or not the unit is itself furnished. 6 is the all-important rent section. And so it's important, number one, that these sections be filled out, specifically having to do with where a payment should be delivered. Additionally, along with the amount of monthly rent that will be owed, it's important to indicate whether or not there will be a prorated amount for either the first or the second month, depending on the way that you fashioned your move-in. Clearly identify when the rent is owed and for what month it applies, again, right at the beginning. You're going to notice that the lease specifically states that rent is due on the first day of each month. And it specifically says that there is no grace period. This is extremely important because many people misunderstand what the function of a late fee and the date of a late fee serve. They don't serve as extra time to timely pay your rent. Your rent, according to Section 6, is due on the first day of the month. And so your tenant must know that and know that no, there is no grace period. And if they fail to pay rent on the first day of the month, they're technically susceptible to a notice to vacate as early as the second day. Now, they may tell you correctly, well, I know you can't assess late fees against me until later. And while that's true, the assessment of late fees is not the issue. Whether or not the tenant is in default for non-payment of timely rent is what is at issue. And it should be clear that the rent is due on the first, and that this lease states very clearly there is no grace period with regard to that due date. Now, the section specifically prohibits payments in cash, which is important. Cash payments can be messy and hard to track, and so you're better off not accepting any cash payments. The section also clearly states that there would be a fee and a penalty for late payment. And so let me talk a little bit about how late payment works. In the state of Texas, for an apartment, you are typically limited to 10% of the monthly rent. That's the maximum that you can charge for a late fee. If your rent is $1,000 for a rental unit in an apartment complex using the TAA lease, you are generally capped at about $100 for late fees. Now, if you can prove to a court that your actual costs in the collection of your late fee exceed $100, then yes, you technically can charge more. But by default, if you cannot otherwise substantiate a higher collection cost for yourself, stay with the 10% rule for an apartment complex. Here's how it works. If your rent is due on the 1st, which according to this contract it is, 2 full days after the due date have to pass before you can legally require a late fee, which means that your tenant can pay the full amount of rent owed on the 1st, the 2nd, or the 3rd day. However, on the 4th, you can legally require that the tenant pay additional fees. Now, it can be up to 10%, but then you can no longer accept any more. So what you may do is say, I'm going to charge 3% or 5% on day 1, and then a single percent until I hit 10% in total. However you figure that out is completely up to you, but make sure that it is clearly delineated in your written lease. Section 7 has everything to do with utilities. Does your apartment complex provide utility service to your tenants? If you do, then you must indicate which utilities are provided in Section 7 of your lease. If you don't, you really should make that clear to your tenant and make sure that the tenant quickly puts all utilities in their own name. Never hand over keys to a tenant when the utilities are still in the name of the apartment owner. This is always complicated and usually a mess. Make sure that once the tenant has keys, that all utilities that need to be transferred are otherwise shut off or immediately transferred into the name of the tenant. Section 8 has to do with insurance and whether or not you will require your tenant to purchase a renter's insurance policy or liability policy. In the event of a storm, generally the apartment complex is insured, but not the stuff inside of it. So the fact that you have insurance for the structure, the apartment building, doesn't mean that your tenant has insurance for their stuff. Make sure that it's clear to your tenants that if they want to be insured, they have every right to purchase their own insurance. Also make sure, if this is a requirement of your own, that you have a preference that your tenants all be insured, then you mark the appropriate box in Section 8 to make sure that that happens. So Section 9 is the "it always gets you in trouble" provision. This is the special provision section where people add all sorts of things. I told you earlier about the severability clause in your lease, and this is one of those clauses that's easy to cut out because many people just throw whatever they want in there, or they throw in something that's already mentioned somewhere else on the lease, and it is just superfluous. It's not necessary and doesn't really serve any good function. But it's your lease and you can put whatever you want into it. I would say, though, if you're going to add something to this lease, make sure that it's something that's reasonable, something that makes sense, and something that you both, landlord and tenant, agree to. However, If you are unsure about a provision that you are using in Section 9 of your lease, consult a legal professional to see if whether or not this is the kind of thing that a court would even agree to, or whether or not it's actually enforceable according to state law. Section 10 has to do with unlawful or early termination. So this section establishes a certain amount of money that the tenant will owe, not to exceed 85% of the maximum amount of the rent, and it establishes essentially a liquidated damages clause. And what this is it gives kind of a ballpark or a rough estimate of the extent of the damage that the landlord will experience if a tenant fails to fully occupy at the beginning and then never comes into the unit, or if the tenant leaves in the middle of a lease term or is judicially evicted. It's a helpful way for the landlord to determine what, if anything, are the economic damages that will be suffered by the landlord in the event of a tenant default. Now, this doesn't mean that this is the maximum amount of the losses that a landlord will experience. Again, it's just some agreed number that both landlord and tenant agree will be due as an additional fee for the breach. It should be made clear to the tenant that even payment of a reletting fee is not them being absolved of all the potential damages that ultimately may be incurred by the landlord. This represents just the agreed upon portion and is generally enough to cover the first part of any of these losses. This section goes on to explain that there might be additional damages and that this particular section and the payment of the reletting fee do not function as a release of all potential claims. You can consider the reletting charge as a down payment of the full extent of the damages that will be owed. And it doesn't limit the landlord from collecting accelerated rent, from collecting unpaid fees, or for making a charge for damages that were caused to the premises by the tenant. So this gets us through page 1 of the TAA lease. If you had questions about sections 1 through 10, which we covered in today's video, please comment below and let me know what you think about this lease. Not all apartment complexes use this lease. If you're not using the TAA lease, let me know in the comment section below what lease you are using. Where did you get your lease and how is it working out for you? If you're interested in seeing a sample copy of the TAA lease, I downloaded it directly from TAA.org and am using this lease only for the purposes of education, knowing that many landlords out there are using this lease. And if you are one of them and have any questions about the use of the TAA Apartment Association lease, please let me know in the comments below. Until next time, if you're interested in additional content, feel free to catch one of our other videos on this YouTube channel. And if you have not subscribed yet, please consider subscribing. But until next time, landlords, happy leasing.